A criminal trial allows the prosecution to present their case, and it also allows the defense to present the defense case. What happens in the beginning is there's voir dire. Voir dire is the process of jury selection, where in California there will be 12 jurors who will try the case. And it's done through a selection process where the judge or the attorneys will ask the jurors questions. After the jury is selected, then the case proceeds to the evidentiary stage where the prosecution puts on their case. And they call witnesses and or present documents and other evidence where they try to prove that the person has committed the crime. After the prosecution puts on their case, then the defense, if they wish, puts on their case. Now, the defense has a constitutional right not to present any evidence because the burden of proof is on the prosecution to prove their case beyond a reasonable doubt. So the defense may or may not put on evidence depending. Then the court develops the instructions. The instructions tell the jurors what elements of a crime have to be proved. And then the jury will decide whether or not the prosecution, through their case, has presented the elements to prove their case. Now, of course, in the case of a defense, we obviously do everything we can to make sure that the prosecution cannot, has not, and will not prove their case. After the jury is instructed, the case goes to the jury for deliberations where they can or may not reach a verdict. A verdict is not required. Obviously, the prosecution and the court would like to see a verdict, but sometimes people cannot agree on what did or didn't happen and whether or not the prosecution did or did not prove their case. At that point, a mistrial is declared if the jury is deadlocked, which is something that can and may happen in a criminal case.